Hello everyone, welcome to the channel Ontario Law and the Older Person, Introduction to Ageism in Employment. And you might be wondering why I would have a video dedicated just to the introduction. Well, that's because ageism can pop up in various parts of employment, from hiring to retiring. And I did start with the idea of doing everything in one video, and I realized if I tried to talk about everything in one video, we'd be here for at least an hour and a half. So I've cut it up into separate units. This is just the video to let you know some of the statutes and some of the issues that pop up in employment. Then we'll move on from there in different videos. The information provided in this video is not legal advice. It is relayed for the purposes of general information. No legal decisions should be made based on this material. Any viewer who needs legal advice should contact a lawyer. So yes, more statutes or laws. I do think it's very important to have just the tiniest of understanding about the statutes and their impact, and I bet you'll be surprised by some of the things you see. This is the Human Rights Code, and we're going to be spending a lot of time on the different sections. I've cut out a whole lot because this statute by itself is very long. I just want to touch on the most basic issues. Going down to Section 5, subsection 1. Every person has a right to equal treatment with respect to employment without discrimination because of or due to race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. Okay, what I'm doing here is I'm reading out what's in the section. I'm not advising anyone to sue someone if they think this is happening to them. First step should always be talk to a lawyer, and that lawyer is not me. Okay, moving on to subsection 2 about harassment in employment. Every person who is an employee has a right to freedom from harassment in the workplace by the employer or agent of the employer or by another employee because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. And I find this phrasing kind of funny because it seems to imply you can harass people in other ways as long as it doesn't fall within this list of characteristics. Vocational associations, Section 6. Every person has a right to equal treatment with respect to membership in any trade union, trade or occupational association, or self-governing profession without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, marital status, family status, or disability. Notice how they don't have a record of offenses in this list. Wonder why? Constructive discrimination. Section 11, subsection 1. A right of a person under Part 1 is infringed where a requirement, qualification, or factor exists that is not discrimination on a prohibited ground, but that results in the exclusion, restriction, or preference of a group of persons who are identified by a prohibitive ground of discrimination and of whom the person is a member, except where. So first I want to say is basically, it's not intended as discrimination, but it has the result of the exclusion. So there's kind of intent versus result, and we're talking about the impact here. Okay, except where A, the requirement, qualification, or factor is reasonable and bona fide in the circumstances, or B, it is declared in this act other than in Section 17 that to discriminate because of such ground is not infringement of a right. And we don't need to look at Section 17. I'm just pointing out to you that it certainly starts out strong. We have all these protections, but we're going to be seeing sections and statutes where that protection is being taken back and taken back and taken back. Subsection 2. The tribunal or a court shall not find that a requirement, qualification, or factor is reasonable and bona fide in the circumstances unless it is satisfied that the needs of the group of which the person is a member cannot be accommodated without undue hardship on the person responsible for accommodating those needs, considering the cost, outside sources of funding, if any, and health and safety requirements, if any. So when we're talking about undue hardship when it comes to human rights, it has a bit of a similar function of the reasonable limits clause in the Charter. So under the Charter, there are no unlimited rights. Under the Human Rights Code, there are no unlimited rights, and that includes accommodation. So you might have an employee who needs accommodation, but does that level of accommodation mean basically ripping the whole workplace apart? So what is undue hardship is going to be determined depending on the context, but I just want to leave you with the understanding there can be fights over whether someone is entitled to that level of accommodation. Maybe there is a different kind of accommodation that is also useful, or maybe it's not possible to accommodate at all. So what does bona fide mean? And for this definition, I've gone to the website of Thomas Reuters, their practical law, and I've just realized that when I refer to a private business website, this might be seen as an advertisement or that I'm getting sponsorship from them, and that is not the case. I just think their definitions are particularly good for getting the point across. Because again, bona fide occupational requirement can have different definitions depending on where you go. So the term bona fide occupational requirement, BFOR, refers to a standard rule or practice that is essential for carrying out the duties of a particular position in the workplace. So that's a quote. For the employer to establish a BFOR, they must prove that the standard rule or practice, this is sometimes called the three-step test. So the practice has to be proven to be rationally connected to the performance of the job, was established in an honest and good faith belief that it was necessary to fulfill the legitimate work-related purpose, is reasonably necessary to accomplish the legitimate work-related purpose. The employer cannot show that a standard is reasonably necessary if it has not taken every reasonable step short of undue hardship to alter the workplace or job requirements to accommodate the employee's protected characteristic. So when we're talking about protected characteristic, right, that list of grounds about, ethnicity, gender, age, what have you. So you have to prove these elements. Now we're back to the Human Rights Code. And so we're looking at Section 23, subsection 1. The right under Section 5 to equal treatment with respect to employment is infringed where an invitation to apply for employment or an advertisement in connection with employment is published or displayed that directly or indirectly classifies or indicates qualifications by a prohibited ground of discrimination. So it could be someone saying, hey, we don't want to hire older people. Obviously, that would be a sign of discrimination, and I doubt you're going to get many ads nowadays that will say something like that, but maybe it will use language that will dissuade a group, such as older people, from applying for the job. And we're going to look at that in another video, what kind of language can be out there. And then subsection 2, the right under section 5 to equal treatment with respect to employment is infringed where a form of application for employment is used or a written or oral inquiry is made of an applicant that directly or indirectly classifies or indicates qualifications by a prohibited ground of discrimination. Questions at interview, subsection 3. Nothing in subsection 2 precludes the asking of questions at a personal employment interview concerning a prohibited ground of discrimination where discrimination on such ground is permitted under this act. Okay, here we have a bit of grabbing away. So on the one hand, it is discrimination, but other sections of this act might say it is not. So it's never clear cut. And then employment agencies, subsection 4. The right under section 5 to equal treatment with respect to employment is infringed where an employment agency discriminates against a person because of a prohibitive ground of discrimination in receiving, classifying, disposing of, or otherwise acting upon applications for its services, or in referring an applicant or applicants to employer or agent of an employer. So just don't say in the applications, oh, wait, this is by a person of this ethnicity or this place of origin or whatever, and just toss it. How you would prove that one way or another, that's a different story. Section 24, subsection 1 is, as I've pointed out there, a long list of situations in which discrimination won't be found. And it is a long list. It refers us to a bunch of other statutes, and it'll take forever. So I just want to focus on this one, 24, subsection 1b. So discrimination won't be found if the discrimination in employment is for reasons of age, sex, record of offenses, or marital status, if the age, sex, record of offenses, or marital status of the applicant is a reasonable and bona fide qualification because of the nature of the employment, right? So saying, do you have a legitimate reason for doing this? If you do, then it's not discrimination. Section 25, subsection 2, the right under section 5 to equal treatment with respect to employment without discrimination because of, and again, the list of grounds is not infringed by an employee, superannuation or pension plan or fund or contract of group insurance between an insurer and an employer that complies with the Employment Standards Act 2000 and the regulations thereunder. So this is the Human Rights Code saying, well, a different statute, Employment Standards Act 2000, can operate by a different set of rules. And then we have subsection 2.1, the right under section 5 to equal treatment with respect to employment without discrimination because of age, so age specifically, is not infringed by an employee benefit, pension, superannuation, or group insurance plan or fund that complies with the Employment Standards Act 2000 and the regulations thereunder. So again, another statute can change the rules on us. So we're going to move on to the Employment Standards Act 2000, leaving the Human Rights Code behind, sometimes literally. Section 44, subsection 1, except as prescribed, which basically means being written down somewhere, no employer or person acting directly on behalf of an employer shall provide, offer, or arrange for a benefit plan that treats any of the following persons differently because of the age, sex, or marital status of employees. So that includes 1, employees, 2, beneficiaries, 3, survivors, and 4, dependents. Sounds pretty good, right? Well, maybe not. So I skipped a lot of stuff that's in that statute because, again, it's a long one. It would take forever. I'm trying to make a particular point, so I moved on to a regulation under that statute. It's called Ontario Regulation 286/01, benefit plans. And one thing I wanted to point out, one of the definitions, and that's the thing for any statute, you should look at the definitions if you're going to look at a statute because the definitions might not be quite what you would expect. So definitions is section 1. Age means any age of 18 years or more and less than 65 years. So that's what they're telling us right in the beginning. So if you're 17 or younger, your protections against discrimination don't apply in this situation. If you're 65 years of age or older, well, this regulation is saying, no, you didn't get protection either. So here we get to a little fun bit. We're still looking at the regulation that is under the Employment Standards Act. So this is about pension plans, permitted differentiation re employees age. Section 4, subsection 1. The prohibition in subsection 44(1) of the Act, and I put in, this is what they mean, Employment Standards Act, does not apply in respect of a differentiation that is made on an actuarial basis because of the employee's age, and that relates to, and so on. So section 44 said, can't discriminate against us based on age, and this regulation under the statute says, yep, we can under certain circumstances. This is the last one I'm going to make you look at, I promise, and just a brief look because I'm just trying to make a point here. So Workplace Safety and Insurance Act 1997. Then we have the Human Rights Code. They address the Human Rights Code specifically in this statute. So we have section 2.1, subsection 1, a provision of this act or the regulations under it, ... that requires or authorizes a distinction because of age applies despite, I put that emphasis there, sections 1 and 5 of the Human Rights Code. So politicians create the Human Rights Code and this gets interpreted under court's decisions or tribunal decisions, but then someone can draft a different statute and say, nope, doesn't apply here. And people who are not familiar with different areas of law, they might not recognize that this is all over the place. This is a report from the federal, provincial, territorial ministers responsible for seniors. It's called Consultations on the Social and Economic Impacts of Ageism in Canada, What We Heard report from December 2023. And it's actually a report I will touch on in a number of videos because it's a big report that covers a lot of issues. The link is in the description, but I'm only going to be looking at one thing from it for this video. This chart reflects the concerns that the participants in the study have about seeking employment and ageism in employment. And as we can see, the biggest concern is discrimination against job seekers in the hiring process itself. So 49.5% say this is their biggest concern. Now, this doesn't mean 49.5% have actually faced discrimination in a hiring process. It's just obviously this is a gatekeeping function. If you can't even get an interview, then obviously you're not going to proceed any further than that. I will be providing additional videos that address ageism in the hiring process, treatment during employment, training, promotions and comments, accommodation, firing, layoffs, and coerced retirement, pensions and benefits. So yes, those will be individual videos. There's a lot more discussion about it than you might know. And we're also going to look at a few court decisions or tribunal decisions to let us know how the laws are playing out in the real world. So thank you for getting to this video and reaching the end of it, and have a great day.